All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you. I note for the record that Mr. Krasniqi is appearing via video link with permission. Mr. Thaçi, Mr. Veseli, and Mr. Selimi are present in the courtroom. I also note that Ms. Allegendra and Mr. Roberts are appearing via video link as they requested, and that the Deputy Registrar is present in the courtroom. First, as communicated by email last week, the panel would like to hear oral submissions from the Thaçi defense in reply to the SPO's response in filing F03132, which is the issue on bifurcation and scheduling, if you have any further comments.
Yes, Mr. President, good morning to the members of the panel. We do request and maintain our request that we do a bifurcated procedure because the Thaçi defense does intend to file a motion in limine. The situation today is fundamentally different than at the time when the Thaçi defense filed the first motion in limine and when the trial panel issued its ruling on it. Namely, since then, a new criminal case has been filed against Mr. Thaçi in Case 12. The SPO motion attempts to move some materials in from Case 12, an entirely separate case, into Case 6. The SPO argues that these materials are relevant to Case 6, arguing that they, first, if proven, would constitute aggravating factors relevant to sentencing in this case. Second, they allegedly inform the credibility of SPO witnesses in this case. And third, they allegedly demonstrate the alleged mens rea of the accused for crimes committed during the indictment period. Mr. Thaçi has a right to file a new motion in limine and to seek new relief in light of, among other things, the new issues that arise from Mr. Thaçi now being a defendant in a separate criminal trial, and the SPO response offers no basis to argue that Mr. Thaçi is barred from bringing his own motion seeking to exclude all evidence from Case 12, given that he is now facing charges in that trial. The SPO motion raises many new issues that implicate Mr. Thaçi's fundamental rights, including his fair trial rights, the right against self-incrimination, having to put on his defense to the charges in Case 12 prematurely here in Case 6, and thus giving the SPO a tactical advantage in Case 12. Ne bis in idem, the SPO motion is attempting to have the Kosovo Specialist Chambers punish Mr. Thaçi twice, once in this proceeding in the sentencing phase, and then again in Case 12. Third, how the principle of res judicata will eventually be implicated unless the SPO is barred from seeking criminal penalties against Mr. Thaçi in two separate cases for the same conduct. Fourth, the right to adequate time and preparation is implicated, given that Mr. Thaçi now has to fight two trials, at least in part, on the same issues that are now going to be raised in two separate cases. I don't wish to litigate those issues now, but just to flag what some of the issues will be in the coming motion in limine. Again, Mr. Thaçi has a right to file a motion, and we intend to do so shortly. Our view is that the only issue is whether the trial panel would like us to simultaneously brief the motion in limine and separately the SPO's motion to admit some of the evidence from the Case 12 proceedings, or else whether in the interests of efficiency we should stay the SPO motion until the Thaçi defense motion in limine is resolved. I also wish to highlight that the trial panel itself has ruled numerous times that we, the defense, or I should say any party, cannot seek relief in the form of a response to another motion. And your decisions on that point can be found at F01359 at paragraph 11, F01737, paragraph 17, and F01776, paragraph 17. We are going to be asking for more relief than just to deny the SPO's attempt to move in some of these materials into evidence, given some of the fundamental rights issues that are now implicated by the SPO's attempt to move in some of the evidence from Case 12 into Case 6. If the panel is minded to deny Mr. Thaçi the right to file a motion in limine, then I would like to be heard on what alternatives can be made, but our position is that there should be no reason to deny him the right to file a motion, and then the issue is how to structure it going forward. Thank you.
Thank you, Mr. Misitich. We will take this under advisement and issue our ruling later today.
Mr. President, if I just may raise one issue. As of right now, our response to the motion of the SPO would be due on Friday. So we would ask for at least for an extension of that, depending on how you rule. So,
Okay, thank you. We'll rule on that also at the same time. Moving on, the panel notes that yesterday the defense requested via email a further extension of 3,000 words for their response to the prosecution's consolidated motion for the admission of evidence pursuant to Rules 153 and 155 and related requests, which is filing F03056. Does the SPO wish to respond to this extension request?
No, Your Honor.
Defense wish to add anything? It appears not. Hold on, guys. Considering that the defense has already been granted a 2,000-word extension, the panel is of the view that a further extension of the word limit is unwarranted. The panel is satisfied that the current word limit is sufficient for the defense to meaningfully address all the issues arising from the SPO's motion. The panel therefore finds that the defense has not established good cause for the requested extension and rejects the defense's request for an extension of the word limit for their response to filing F03056. Now, I realize today we have an agenda, but before we get to that agenda, I have a series of oral orders that I want to issue dealing with issues that have arisen during the trial and that had not been dealt with yet. So we will go through those first. There are about 10 of them. And then we'll take a 10-minute break, and then we'll proceed with the agenda that I previously sent out to everyone. So first is an oral order on the reclassification of W04264's statements on the admission of a public redacted version of P01955.1. The panel notes that on 24 March 2025, upon the SPO's request, the panel ordered the reclassification of parts 2 through 9 of both the transcripts and audiovisual recordings of W04264's SPO interview, and that only part 1 thereof shall remain confidential. I am referring to the English and Albanian versions of the transcripts of W04264's SPO interview admitted as P01955.1 to P01955.9 and to the corresponding admitted audio-visual recordings thereof. Having reviewed the classification of the remaining statements of W04264, and in light of the SBO's submissions in its email of 20 January 2025, the panel is satisfied that P01956, P01963, and P01964, and any translations thereof, can also be classified as public and instructs the registry to proceed accordingly. Furthermore, the panel notes that the SPO tendered via email the English and Albanian public redacted versions of Part 1 of the transcripts of W0264's SPO interview, which had been admitted as P01955.1 ET and P01955.1 AT and classified as confidential. The English and Albanian public redacted versions which have been tendered are items with ERN numbers 054739-TR-ET Part 1 RED PRV and 054739-TR-AT Part 1 Revised RED PRV respectively. If there's any objection from the defense to the admission of the public redacted versions of P01955 into evidence, please let me know at this time. No response is given. Thank you. Having found the English and Albanian versions of P01955.1 to be admissible, the panel is also satisfied that the corresponding public redacted versions are admissible. The panel therefore admits admits 054739-TR-ET Part 1 RED PRV and 054739-TR-8T Part 1 Revised RED PRV into evidence and instructs the registry to assign those items exhibit numbers matching the confidential versions and to classify the admitted public redacted versions as public. This concludes the first oral order. Number 2 is an oral order on F02437. The panel will now rule on filing F02437 where pursuant to the panel's fourth oral order of 15 January 2024, the prosecution tendered the audio-video recordings of witness statements previously admitted pursuant to Rules 143, Paragraph 2, Subparagraph C. The panel notes the SBO's submissions that it only seeks admission of the video segments at the timestamps specified in Annex 1, as they correspond to the admitted portions of the statements. The panel considers that only those sections of the video corresponding to the admitted portions of the statements should be admitted into evidence. The panel therefore instructs the SBO to prepare excerpts of the relevant and audio-video recordings corresponding to the admitted portions of the statements by no later than Friday, May 2, 2025. Having found that the relevant statements are admissible pursuant to Rule 143, Paragraph 2C, the panel therefore admits into evidence the corresponding audio-visual recordings of these statements or excerpts thereof as identified in Annex 1 to the filing F02437 and directs the registry to assign the admitted audio-visual recordings the same exhibit numbers which have been assigned to the relevant statements as indicated in Annex 1 to filing F02437. The panel further directs the SBO to make submissions on the classification of the admitted audio-visual recordings by no later than Wednesday, 30 April 2025. This concludes the second oral order. The third oral order on the request to access confidential filings in Case 04, Case 05, and Case 07. which are F03062 to F03063. The panel notes that on 27 March 2025, in filing F03062, the Vesely defense requested access to and use of selected confidential filings from case 04, 05, and 07 before the specialist chambers. On 28 March 2025, in filing F03063, the Thaçi defense joined the request. On 7 April 2025, in filing F03091, the SBO stated that it does not object to the defense having access to the identified filings in case 04, 05, and 05. However, the SBO objects to the defense having access to confidential filings in case 07, as it submits that no legitimate forensic purpose has been shown. The defense did not reply. The protective measures in case 04 and 05 were ordered by trial panel 1. The protective measures in case 07 were ordered by trial panel 2. The panel has, in accordance with Rule 81, subparagraph 4, sought and received the views of the trial panel 1 in respect of the request. On 18 April 2025, the judges of trial panel 1 indicated that there are no reasons to maintain vis-a-vis trial panel 2 or the parties or victims' counsel in case 06 any of the redactions contained in the public redacted versions of the selected filings in cases 04 and 05. As regards case 07 filings, the judges of the trial panel 2, in their capacity as the judges who ordered the protective measures in case 07, have reviewed the relevant filings and considered that there are no reasons to maintain vis-a-vis the judges of trial panel 2 in their capacity as the judges in case 06, or the parties or victims or victims' counsel in case 06, any of the redactions contained in the public redacted versions thereof. The panel observes that the Vesely defense has identified the documents for which access is sought in accordance with the panel's past jurisprudence and that of other international criminal tribunals. The panel is of the view that there is a specific legitimate forensic purpose for the access sought by the Vesely and Thaçi defense to selected confidential filings in case 04, case 05, and case 07. In this regard, the panel observes that cases 04 and 05 overlap in a limited way with the present proceedings. In addition, the panel considers that access to the identified case 07 filings may assist the defense in the present case in making submissions in relation to prospective motions pursuant to Rule 130, which the defense indicated they intend to file and exceptionally grants access to these filings on that basis. Regarding the protection of witnesses and victims, the panel notes that pursuant to Rule 81, subparagraph 1A, protective measures ordered in other proceedings shall continue to have effect mutatis mutandis in case 06. The panel further notes that the judges in the trial panels assigned to case 04, 05, and 07 considered that there are no reasons to maintain the redactions contained in the public redacted versions of the selected filings. In light of the above, the panel is satisfied that granting the request would be consistent with the need to ensure the protection of the witnesses and victims, provided that the selected filings remain confidential in case 06. Accordingly, the panel authorizes access to and use of the confidential versions of selected filings in cases 04, 05, and 07 as identified in the request F03062, paragraph 18, to trial panel 2, the parties and victims counsel in case 06. The panel directs the registry to ensure that Trial Panel 2, the parties and victims' counsel in Case 6, are granted access to the confidential versions of the selected filings. Finally, the panel reminds the parties and participants of the confidential classification of these filings and that pursuant to Rule 82(1)(b), their confidential portions shall not be disclosed to the public. This concludes the third oral order. Oral order 4 on concerning 4D00091 MFI and 4D00092 MFI. On 30 October 2024, the panel marked a document with evidence reference number 105714 to 105724 for identification as 4D00091, and another document with evidence reference number DJK01084-ET to DJK01096-ET as 4D00092. The first document is an official report, and the second document is an open source article entitled Bonfire for State Secrets. The defense tendered these documents through witness W04798. The SPO did not object to the admission of these documents. The panel is satisfied of the relevance of these documents since W04798 commented on the documents and their content is sufficiently linked to issues material to this case. Regarding authenticity, the panel is satisfied of the prima facie authenticity of the documents as they bear all relevant markings of origin, including the author and the date when they were issued. Regarding probative value, the panel is satisfied that a sufficient contextualization has been provided in relation to both documents and is therefore satisfied with the prima facie probative value of the documents, which is not outweighed by any prejudice. Therefore, the panel finds that MFI 4D0091 and MFI 4D0092 meet the requirements of Rule 138 and admits them into evidence. The document's MFI status is vacated. This concludes the fourth oral order. Oral order on P00073.1 MFI. The panel will now issue an oral order admitting Exhibit P00073.1 MFI into evidence. The panel recalls that on 18 February 2025, during W04491's testimony, the SPO tendered for admission a document with ERN SITF 00423-766 to 00423-798 and its English translation, which were subsequently marked for identification as P00073.1 and P00073.1 ET, consisting of a clearer version of P00073 and translation thereof. The defense communicated through inter-party communication that it does not object to the admission of P00073.1 MFI. The panel recalls that on 11 May 2023, it held that P00073 met the admissibility standard under Rule 138, as P00073.1 consists of a clearer version of P00073 and revised translation thereof. The panel admits it into evidence and directs CMU to vacate the document's MFI status. Item 6 is an oral order on 4D00093 MFI, 4D00094 MFI, and 4D00095 MFI. There are some outstanding documents that the panel marked for identification which the panel will rule on. First, the panel recalls that on 31 October 2024, during W04758's testimony, the Krasniqi defense showed to the witness and tendered for admission documents with ERN DJK 01037 to DJK 01037, also DJK 01038, DJK 01039, and DJK 01036 to DJK 01036 and their corresponding English translations. The panel marked these for identification respectively as 4D00093, 94, and 95. The three documents are press articles which suggest that a victim of an alleged crime described in the prosecution's pretrial brief had himself later been convicted of serious crimes and is said to have absconded from justice. The Krasniqi defense argued that the articles are relevant to assessing the credibility of an alleged victim. The SPO objected to the admission of the three documents, arguing that the credibility issue had been explored with the witness to the extent he was able to answer the questions, and there was no additional need to have the press articles admitted on the record. Having considered the parties' submissions, the panel finds that the three documents meet the prima facie requirements of Rule 138. Regarding relevance, the party considers that the three documents are relevant to the credibility of a person who was allegedly detained by the KLA and about whom several witnesses, including W04758, have testified. The panel notes, however, that the individual who is subject of these articles has not been called to give evidence. The relevance of the item is therefore linked to the account that this individual is said to have given to another person who gave an account of it to this panel. Regarding authenticity, the panel considers that all three documents, which are online articles published by various news outlets and which are dated, are prima facie authentic. Regarding probative value, the panel notes that while the accuracy of the information contained in media articles cannot be independently verified, the three articles cover different date ranges, are from different news outlets, cite different sources, and suggest that the alleged victim had been convicted of serious crimes in Kosovo and had fled Kosovo. The panel finds that while the documents are of marginal relevance, they bear some probative value, which is sufficient to meet the prima facie standard. The panel considers that the admission of the three items causes no prejudice, as they were used and discussed in court, and the parties and participants could have questioned the witness further if they found it necessary to do so. Accordingly, the prima facie probative value is not outweighed by any prejudice. The fact, however, that W04758 was unable to meaningfully comment on the content of these articles, and that the individual concerned has not been given an opportunity to address the truth of their content, will be accounted for when assessing the weight and probative value of these items. In light of the above, the panel admits into evidence 4D00093, 94, and 95, and instructs the registry to vacate their MFI status. This concludes the sixth oral order. Oral order number 7 on dealing with 1D00046 MFI. The panel will now rule on the admission of the document temporarily marked for identification as 1D00046. The panel recalls that on 5 September 2023, during the testimony of witness W04018, the Thaçi defense tendered for admission an extract of a judgment of the District Court of Pristina. This document bears ERN 032228 to 032286, to 032286, and the witness was specifically shown page 032278, which the panel subsequently marked for identification as 1D00046. The SPO objected to the admission of the tendered document on the basis of relevance. The SPO also stressed the panel's previous findings regarding the lack of utility in admitting portions of judgments into evidence. Having considered the parties' submissions, the panel finds that the tendered document does not meet the requirements for admission of Rule 138. Regarding relevance, the panel considers that the tendered document contains information relevant to the charges in the indictment as it relates to the alleged existence of lists and/or their use by the KLA as a basis for the detentions of alleged opponents of the KLA, including W04018. Regarding authenticity, the panel is satisfied that the tendered documents, which consists of a portion of a judgment of the District Court of Pristina, is prima facie authentic. However, regarding probative value, the panel first notes that the substance of the tendered document relates to findings made by another court based on a different record of evidence than the one on which the panel will make its findings. Second, consistent with its earlier rulings, including in not only the panel's second oral order of 7 November 2024 and first oral order of 30 January 2025, the panel reiterates that it is not bound by the evidentiary findings made by other courts. In the present case, the panel takes into consideration that unlike other instances where it has allowed a portion of a judgment for contextual matters, such as F01733, the tendered portion of the judgment pertains to the panel's sole responsibility to assess certain important factual matters that are at issue in the indictment and in dispute between the parties. Therefore, the panel finds that the tendered document has no or insufficient probative value to meet the prima facie threshold. In light of the above, the panel denies admission of 1D00046 into evidence, and this concludes the panel's 7th oral order. The panel will now rule on admission of the document temporarily marked for identification as 1D0074. The panel recalls that on 6 December 2023, during the testimony of witness W02161, the Thaçi defense tendered for admission a document bearing ERN DHT 02782 to DHT T02783 and its English translation. This is at transcript page 10701. In light of certain inconsistencies related to translation, the panel instructed the Thaçi defense to submit a revised translation, their version, and temporarily mark the document for identification as 1D00074. The panel notes that pursuant to the panel's instructions on 6 December 2023, the Thaçi defense submitted a revised English translation of the tendered document. The SPO objected to the admission of the tendered document, arguing that it did not know its authorship and sourcing, and that the document had been put to the witness and the witness was not aware of the article. Regarding relevance, the panel considers that the tendered document is relevant to W02161's evidence about alleged attacks occurring in Kosovo in 1998 and 1999 against Kosovo Serbs and Albanians. Regarding authenticity, the panel considers the tendered document, which consists of an online article published by the Courier on 18 January 2014, is prima facie authentic. Its origin and source are apparent from the face of the document. Regarding probative value, the panel notes that the article appears to rely entirely on an interview between an individual and the publishing outlet, Courier, without reference to additional sourcing, which have not placed on the record of these proceedings or tested in court. In addition, the witness was not able to comment on the article. Having said that, the panel notes that the issues in the article are also covered in Exhibit Exhibit 1D 0075, which was put to the witness during cross-examination and admitted into evidence. Accordingly, the panel is satisfied that Exhibit 1D 1D00074 has some probative value. This being said, absent any indication of the origin and reliability of the information it contains, the document cannot be relied upon for the truth of its content. For these reasons, the panel finds that Exhibit 1D0074 MFI meets the requirements for admissibility under Rule 138. The panel therefore admits it into evidence for the above said limited purpose and directs CMU to vacate the document's MFI status. This concludes the 8th oral order. One more. The panel will now rule on the admission of P01199 MFI. Madam Court Officer, please bring us into private session.
Your Honors, we are now in public session. Thank you.
Having concluded these preliminary oral orders prior to the agenda, we will take a 10-minute break, and then we'll reconvene in 10 minutes to take up the agenda as previously sent out to you all. So we are adjourned for 10 minutes.
All rise. All rise.
Be seated. Have to use this. Sorry, I had an equipment failure. So we will begin going through this agenda. We sent it out some time ago. We will go through the agenda to the end, and then we will, hopefully with the answers and the information we receive and get with you, we will take a break until after lunch. So at 2:30, we'll come back and issue some limited oral orders to deal with any issues that arose during the discussions we have. So let me begin by just asking the SBO to confirm that they, in fact, have submitted their case entirely and nothing left to do but answer filings if they come up. Anything further to add at this time?
That's correct, Your Honor.
No supplemental matters are expected?
As you said, there are going to be filings, things like replies to existing
Yeah.
litigation, but no supplemental
Nothing
requests.
from you, thank you. So then we turn then to the Rule 130 issues that we've been waiting for. I'd like you to, you've indicated, I know, that you intend to file a Rule 130 motion. Is that all of you? Everyone intends to, each team? And if so, is it to be singular or is it going to be consolidated?
Yes, Your Honor, all four teams intend to file a joint Rule 130 application.
Thank you very much. I don't have to beg for that now because that was on my list of things that we would like to have had to make things a little bit easier. You had indicated that you needed, of course, the rule allows for a 10-day period, and we indicated earlier we wouldn't hold you to that strictly. You had indicated once before you needed 30 days in order to prepare that. Is that still accurate?
Your Honor, in discussions with the defense teams, given the volume of material that is now, of evidence that's been tendered by the prosecution that needs resolution, our position is that we would like 14 days from the date of the trial panel's last decision on evidence that the prosecution has tendered. We can't make a Rule 130 submission without knowing what is the evidence in the record, the complete evidence in the record.
All right.
So 14, final decision plus 14 days, which in our view, would put us somewhere in June when our Rule 130 would be due, assuming that you take about a month to resolve all of these issues.
And you'll be ready to proceed if we can do it faster than that.
Well, that raises a separate issue, but then we would like at least until June 1st. But as we're looking at the current briefing, I understand that one of our responses is due on the 5th of May to one of the bar table motions. Then there'll be a reply by the SPO, and then
It'll take a certain amount of time, I understand.
yes.
I understand your request, I
yeah,
think.
as I understand, there may be till mid-June that we would like to file the Rule 130. But we've calculated out, again, on how we anticipate how long it might take the panel to issue its last ruling. But if it's going to be shorter than that, then, you know, we think it'd be about mid-June would be sufficient.
Anybody else have anything to add to that from the defense? You don't have to, I understand.
Thank you, Your Honours. We would ask that the earliest be the middle of June, given the huge volume of material that has come through and the decisions that are awaited. And Your Honours did indicate earlier that 30 days was a reasonable time period, and also that we'd have to wait for decisions to know what the full case was.
I don't think any of us had any problem with the 30-day limit. It just, we're expanding that now, so we have to take that into consideration. Well, let's hear from the SPO. Do you
Yes.
have any
Thank you.
particular objection?
Yes, we note the expansion as well, but we defer to the discretion of the panel on the timing.
And from, I'm sorry, from the SPO, what kind of timing would you need to respond?
We previously asked for a reciprocal extension of a month. I don't think that changes as a result of the discussion we had just now. And for the record, we were also planning on filing a consolidated response.
Mr. President, if I could just clarify, we don't perceive it to be an expansion, just because we frankly, I think at the time we made those submissions, we're not aware of the huge volume of material that was coming.
I'm not using that term in any way to indicate a feeling I have about it. I'm just saying it is more than what we had originally thought, that's all. We'll have to take this up to, after the meeting, and we'll make a decision later today so that you all know where you stand. So we'll do that. Just for the record, the rules allow for a motion and a response and no reply. Once that, we will stick to that. There is a provision that there can be oral arguments. Does anybody have an intention to make oral arguments after filing the Rule 130 motion, or a wish to make them? And if so, if you do, I guess our question would be, what is it that you can't put into your motion that you need to put in an oral argument?
We do request an oral argument, and basically, since there is no written reply, it would be our reply to the arguments of the prosecution.
But the point is, there's not supposed to be a reply. So
But there is an option to have oral argument. So essentially, what we would be arguing in oral argument would be what we're at issue on, which we can't tell you until we see what the SPO's response is, and they need to see what our motion is.
Response?
We're available for any hearing the court requires.
Okay.
Your Honour, if you
ahead.
can just add as well that it is somewhat akin to the closing arguments where there's simultaneous filings and then an opportunity in the oral submissions to address what has been filed and what arises, plus to answer any questions and concerns your honours have as well. So we would therefore say that, although it's not obviously the same, it's a significant moment in the case, and therefore oral submissions are warranted.
We are intent on setting a word limit for the 130 motion. We would seek to have some estimates from you first, since you'll be filing first.
Yes. Your Honors, in light of the fact that we'll be filing jointly, we propose a joint filing of 20,000 words. I think separately, we'd each be entitled to 6, so it'd be 4,000 less than we would file separately. Thank you.
Response?
No position on that. We would just ask for the reciprocal extension of words for a consolidated response.
Your Honours, and if I could just add, we would ask that once Your Honours have given that indication, because this is something of a moving target with many decisions still to come, that there be an opportunity, I think as there always is, to come back to Your Honours to request any extensions that may be necessary, depending on the issues that are to be raised following consideration and instructions from our clients.
Yeah, without saying that we would be particularly receptive to that, not that we couldn't be, and you can always file a request.
Yes.
Certainly you may.
Yes. Thank you, Your Honours.
Also, for the record, there's no appeal from the defense should the 130 motion be denied, and I'm sure you're all aware of that. So I want to turn now to the victim's case, Mr. Laws. Assuming that one or more of the accused, now we know all of them in a consolidated manner, will file a Rule 130 motion. It's our intention to have Victims' Counsel present the case for victims as soon as possible after the decision is rendered on the Rule 130 motion. And in order to do that, we need to have certain declarations ahead of time. So I want to know if you could speak a bit to when you would be able to list your proposed witnesses, list their reports, if any, that type of material. So you go ahead, you have the floor.
Well, certainly, yes, I can do that. May I deal with expert evidence first of all?
Sure.
We have commissioned 2 expert reports. One deals with psychological and psychiatric evidence, and one provides some figures in relation to material harm or economic loss. Both of the reports have been received by us over the Easter break. One is in Dutch and has been sent for translation. The other is in English. We therefore are very hopeful that, assuming there's no delay with the translation, we will be able to file both reports by the end of next week, the 2nd of May, with the appropriate request under Rule 114.5.
Let me stop you for just a moment, Mr. Laws.
Yes.
We were considering to have you do that by May 14th. You could certainly accomplish that.
Yes, there'll be no difficulty with that, and I'm very happy to do it earlier if the material is available.
You can file it whenever you have it available to you, but
Thank you.
we'll consider a cutoff date of May 14th, if that's all right.
Yes, certainly. Thank you. Secondly, then, there's an associated topic, which is this, that both sets of experts that we will be relying upon in this case, in Case 6, have also provided reports in Case 4 and Case 5. And we intend to rely on those reports from the earlier cases, given the overlap that Jonna referred to earlier. We intend to rely on those reports in this case, and that, in our view, will require an additional filing. So we would certainly aim to be able to do that by the 14th of May as well. So there's then an issue about the remaining aspects of our case, and we have in mind in particular paragraph 72 of the Order on the Conduct of Proceedings, instructing the parties and, for these purposes, the participants, to present its case in a logical manner and to notify the panel of the overall sequence in which it proposes to present its case. And what we have in mind is a filing, which we can certainly do by the 14th of May as well, in which we set out a guide or roadmap to the rest of our case, indicating what submissions we're going to be making and on which topics. And I don't need, I hope, to go into those this morning, but there are a number of written matters that we want to take up with the panel, and we're happy to give an indication of the topics by the 14th of May, with a view to there being filings later in the case. And then...
I'm sorry, would that include an exhibit list, Mr. Laws?
What we have in mind would be to file a bar table motion after the 14th of May. That's one of the motions that we have in mind to list, and so ultimately we will be producing an exhibit list, but not by the 14th of May, if that makes sense. So finally, on this aspect of the state of preparations, we propose to file a request to call other witnesses or make applications under Rule 153/155, and we're going to ask for slightly later than the 14th of May for that, if we may. We would like to do that by the 28th of May. So those are the matters that we're going to be filing upon, so that the panel and the defence are not in any doubt about it. When I talk about calling witnesses and submitting a request by the 28th of May to call witnesses, I'm not including in that documents that we have been preparing for the victims, which are effectively victim statements or supplementary information on the harm that the victims have sustained, which we're going to be describing in full detail in our filing by the 14th of May, but that is a separate category of material that won't involve, that certainly won't involve calling witnesses to testify live, but will provide, we hope, additional information about harm only in respect of a very large number of the victims in this case. And that's a filing that we see coming significantly later than May, but as part of our case. So depending on where the conversation goes next, it rather looks like our case is going to be either just before the recess or after, and we would be looking to submit that material at that time. So those were the only matters that I wanted to raise, Your Honour, in terms of the shape of our case and what we have in mind. I should mention that the experts who we anticipate to be testifying, subject to Your Honour's approval, are experts in relation to psychological and psychiatric evidence. We anticipate that those are going to be the viva voce witnesses. Their availability is limited. They're not just available at the drop of a hat. We've been in touch with them and spoken of the dates, the week of the 7th of July and the 14th of July, as being times when they would be available. It doesn't look as if that's necessarily going to work on the timetable that we have. So I raise that now. The week after, the 21st, I think may be impossible for them. So just so that you have a full picture.
And how many? Once again, do you have a better estimate of how many days you anticipate being in court?
Well, I can't really improve on saying that I'm confident it won't go into a second week. Subject to Your Honour's leave, I'm confident that we will call the psychological and psychiatric evidence. That may take more than a day, and then it'll just depend whether there are victims who wish to testify live, and we will have that clear for the court, as we've said, in line with the dates that I've given.
I have a couple of questions for you, Mr. Laws, to be sure that I've understood you properly. Are you saying that you would have any difficulties providing a list of proposed witnesses and exhibits by the 14th of May, even if those lists are, of course, tentative? I understood you to be saying that you would not be able to do so by that date. Is that right?
So far as indicating the witnesses are concerned, Your Honour, we have suggested a later date for a filing in which we set out the witnesses that we propose to call in addition to the experts, together with the applications, if any, under Rule 153, Rule 155. So the date that we've suggested is the 28th of May for that, and at that stage we would be able to provide the list of witnesses and exhibits.
Thank you. And that links up to my other issues, because of course once notice is given, the parties will need some time to prepare for your case if one were to be presented. Have you engaged in discussions with the defense and the SPO as to your prospective case and what it might look like, with a view to ascertain the extent of opposition, if I may call it that way, that there might be from the parties in respect of that case? I'm not asking for any detail, just a sense of how quickly the case could last.
Well, I have had discussions with Mr. Misetic representing the defence and indicated to him the areas in respect of which we would call expert evidence. Slightly later on the delivery than I had said to him that I would be, but we have had that discussion. It would be very difficult for me to ask him or anybody to agree in advance what the areas of agreement or disagreement are likely to be, because they're not going to know what's in the reports till they get them, in fairness. So far as individual victims are concerned, we have not had discussions with the defence. We have not as yet finalised the list of people who may be called, and it's partly for that reason that we ask for a slightly later date in May. Your Honour would appreciate that there are more than 100 people in the category of victims who have not testified but who would be eligible to do so, and conversations in relation to that topic are ongoing.
Thank you.
Do you know at this time when you would be prepared to file your bar table motion?
Can I say that was one of the motions that I suggested we would include in a filing by Your Honour's date of the 14th of May. It will not be a substantial filing. There are just a handful of documents that we think need to be put before the court in that way, and we're perfectly happy to have a date to do that set today, but yes, the 14th of May seems to be a reasonable date for that, or perhaps the week after.
And is all of your documentary evidence going to be ruled by the bar table motion? Or will there be some admitted separately?
There may be some admitted as exhibits to Rule 153 material.
So if we use the dates that were suggested by the defense and agreed, not necessarily agreed to by the SBO, but accepted by the SBO. It's going to put you right up against the summer break, and that might be uncomfortable. And it sounds like you may not have an available or two available experts. So would it be safe to say that you would, if we accept their dates, you'd probably need to start after the summer break?
On the dates that we have, Your Honour, if the defence take 30 days from mid-June, and therefore the prosecution reply with 30 days from that, it takes us right up to the date, to the date of the recess, without any time for a ruling, in fact. So, yes, and from our point of view, we would much prefer to have a date fixed now and work to it than to have a provisional date that needed to be reviewed. We would much rather that.
Yes, and of course, that's the reason for asking these questions,
Yes.
because we agree with you about that. The sooner we can get some dates fixed, the sooner everybody will pay attention to those and deal with them.
Yes,
Any other questions for Mr. Laws? Thank you, Mr. Laws.
thank you.
Mr. President,
Yes.
if I can just comment on behalf of at least the Thaçi defense. From our perspective, Mr. Laws correctly spelled out what our communications have been. We were not, prior to this morning, aware of that there would be, for example, a bar table motion and some a motion concerning additional witnesses. It would obviously be of an advantage to the defense preparations for the victim's case if we started after the summer recess. And we too had planned and hoped to do that before the summer recess, but in light of all of the different things that are happening, I'm not sure we can fairly process all of this material and be ready to cross-examine expert witnesses in the middle of July. Thank you.
Your Honours, if I could echo that and also emphasise, as has been foreshadowed in the questions of His Honour Judge Matreau, that there would be the need for the time for preparation by the parties for the victim case. And that would depend, of course, on the number of witnesses to be called. So the earlier that notification can be given, even if it's preliminary, would be so much better, because at least the work can start. And if there are witnesses dropped, well, so be it. But having that indication as soon as possible would be a request we make.
And that, I understand your request. I understand that. I understand the need to know, and that's part of why I continually trying to find out what kind of a defense there is, at least as to time frame. If we just knew, we think it'll take a month, or we think it'll take 2 months, it would help us very much in making other plans. So I ask you again to think about that and to see if there is some way you can aid us for scheduling purposes only. We honestly don't care at this point who you're calling or how many of them there might be, or what you're going to present as in the way of documentary evidence. But it would be helpful to have some time frame that we could wrap our heads around. So,
Mr. President, for what it's worth, you've asked us that question before, and
Yeah.
I've given you, and first of all, we don't know that we're going to call a defense case.
I
That's
know.
still the case, but I was asked, I believe, by Judge Gaynor at a status conference months ago,
Yeah.
how many we would
You
call, and
said-
I said up to 10. So if that gives you any assistance.
But there are
I'm just
14.
speaking on our behalf, so thank you.
And I don't know if that counts for everybody or if that counts for just you, so.
That counts for just me. So, thank you.
Anybody else want to add to that? I'm not trying to pin you down. As I said, I'm just trying to schedule this, keep this monster moving in one direction.
Yes, sir. Your Honour, I'm not able to say much more than I've said before, which is that is a situation under review. But I can say that I think we'd be looking at a fairly limited time in comparison to what has happened throughout the case so far. I'm just considering whether, if the defence teams have an opportunity to consult, whether we couldn't give a rough overall estimate for all four to Your Honour's.
I'm not asking you to do that right now, but yes, I would ask you to continue to consult about that.
Yes, because that could then help planning it forward and knowing when the end date is going to be, which we appreciate is very important to have in mind.
And one more thing about the victim's case is, and that is, as always, we encourage inter-party discussions about these matters, especially on issues of documents and whatnot. It may be that that can move faster than we thought it could if people don't have a big objection to any particular one.
Certainly.
Same thing with prosecution, if you can be open to that also. And defense. Everybody, at this point, it's helpful to have some discussions. Yeah, the rest of the things that I have down really have to do with scheduling the preparation conference for the defense, and there's no reason to go into that detail today because we don't know when it's going to happen. I refer you to the rules. They're quite specific on how this happens and the timing, so everyone should be ready to comply. Mr. Dixon, you brought this up just a minute ago, and
Yes, sir.
the question we have for you is, when you're discussing these matters of timing, could you also give us some idea when you would know in more detail what your defense might be?
Yes, the length of time that it might be.
Yes.
Yes.
Yeah. And when would you, and when we're asking, when would you be able to reveal that to us, if you would discuss that?
Yes,
All right?
indeed. So it's two time periods. One, if we're able to say quite soon what roughly the
Yes.
total time period would be, but then secondly, when we'd be able to give something more definite
Yes, yes.
and be able to give that so that could be factored into timing. Yes,
That would be helpful.
we'll consider that.
That would be helpful.
Thank you, Your
Surely you've thought about these things and are working on these items anyway.
Absolutely,
And
yes.
so and even press releases are being made concerning the fact that things will be, that a Rule 130 motion will be filed, for example, or that witnesses will be called. Those things are being talked about, so that's why we're curious about them
Yes.
as well.
I haven't made any such statements, but there have been, of course, these matters considered internally on an ongoing basis. So we will be able to come back to you, Honours, on those time periods.
Thank you very much. Thank you very much. I wouldn't want to leave this meeting without telling everybody that you've been extremely cooperative and thoughtful about how this case can proceed. I know it's not easy. I know it's a difficult case. I know it's a difficult number of witnesses and exhibits, but everyone has done their best to abide by the suggestions that have been made and by the promises that have been made. And we appreciate it. We aren't just sitting here complaining about things. We actually recognize the effort that it takes to make a case like this come to, at least as far as the SBO is concerned, to a finish line on time. And it took not only the SBO's efforts, but it took the defense efforts and the Victims' Council's efforts as well. So we appreciate that. Just don't want to miss anything I've written down here. A couple of notes. We once again will confirm that we still do not intend at this point or have any intention to call witnesses or to submit documents on our own. We realize that things can change, but that's certainly our intention at this time. And just another note, all 4 defense teams, just as a reminder, since you weren't all here at the beginning, gave an opening statement at the beginning of the case in early April of 2023, so we do not expect an additional opening statement prior to the presentation of the defense cases, because we've heard it once already. Is there anything else you wish to bring before the court at this time? Anybody?
Yes, Your Honor. On a matter that has been brought to our attention by Mr. Salimi, he's had some difficulty with contacting the outside world, specifically his family. We believe these are related to the modified detention conditions, which I'm not going to relitigate here, but I refer the panel to our pending motion filed on 13th of December 2024. That's F02785. And the litigation chain has concluded. We received a response. We replied in due course. Victims' Council made observations, and we responded to them. We are highly cognizant of the vast amount of litigation before the panel and indeed the parties, but given the ongoing impact of the modified detention conditions on Mr. Salimi's life and our maintenance that these conditions are no longer necessary or proportionate, the resolution of the matter is of utmost importance to us and more so to Mr. Salimi. So with that in mind, we respectfully ask for guidance from the panel as to when we might expect a decision to be rendered on that issue. Thank you.
We will give you an indication yet today. All right, we will,
Mr. President,
yes, go
just,
ahead.
2 points. One is I just want to give you, so you're fully informed as you go back to have your discussions. On the motion in limine issue, I should have mentioned earlier, our request is we need 12,000 words for the motion in limine and 6,000, which is the standard response for the response to the SPO bar table motion, just so you have the numbers in front of you. And we would request an extension of time for both to put in, if you're inclined to force us to respond to the SPO motion by May 8th. That's our request. I just wanted to put that on the record. The second issue is that, yes. The second issue is that Mr. Thaçi respectfully requests that he be allowed to follow the proceedings after the lunch break from the detention unit, and we will fill out the appropriate forms to do that.
Of course, you may.
Thank you.
Your Honor, it's just 2 brief matters which we'd asked to be dealt with at the end of the agenda. The first was regarding Mr. Vasili's reoccurring problems, at least over the last 3 months, of being able to speak to his children on the telephone line. There have been extensive interruptions and difficulties in being able to communicate with them. Fortunately, we have had a detailed response from the registry on this before the hearing, and an interim solution has been found, and they're looking into the matter. But I did wish to place it on the record. Mr. Vasili did wish to emphasize that this has been an unacceptable situation which has interfered with his rights and also disrupted his focus on preparing his defense case. And we will be keeping it under review so that if the problem is not resolved, we can revert to the registry and your honours if necessary. But we are hoping now that it can be resolved. So I did wish to raise that. There's no longer any need to discuss it further today. And then secondly, honours, with regard to detention visits and having access to Mr. Vasily, I believe this is also a matter that has arisen with the other teams as well. Without going through all of the details of it, the number of it is that we wish to ensure that we are able to have notification well in advance that visits have been confirmed, so that we're not waiting until the last moment, and that affects travel arrangements and logistical arrangements. So it's a matter we're taking up with the registry, but we did wish to raise it before your honours because it was on the agenda, but although it might not be a matter your honours can rule on, to give a clear indication that it is essential that confirmation of visits is given as far in advance as possible. We've asked for 10 days in advance so that proper arrangements can be made, because of course at the moment it's vital to have access to our clients when we're not in court all the time, to be looking at all the matters we've discussed, including preparing the defence cases.
Thank you.
Just briefly to join and to alert the panel that Mr. Thaçi is having the same issues with respect to telephone calls to his wife and son. We understand from Mr. Dixon that he is in communication with the registry to fix that issue. I just wanted to put that on the record. The second point is I had also raised in an email to the panel, an issue with my ability to visit with Mr. Thaçi yesterday. The registry and Mr. Nielsen particularly intervened to resolve that problem, for which I wish to express my gratitude on the record to Mr. Nielsen for resolving that. And I would just like to note that we don't know what all the issues are that the detention unit has in arranging these visits, but to the extent that we can work cooperatively for them to share with us what the issues are so that we can perhaps work around them together to facilitate these visits, we're more than open to doing that. Thank you.
Jonas, do you have anything you'd like to say about this?
Thank you, Your Honours. As much as I would like to take credit for the solution that was found yesterday, the reality is that that was resolved without me particularly being involved. So I'll try to explain what happened. What we're talking about is essentially a question of availability of visiting rooms. That's the issue. We are in contact and in constant exchange with the defense teams to accommodate the legal visits by counsels, in addition to the other visits that the detainees have. Now, there are a certain number of visiting rooms that can be used for this purpose, and we are using them to the maximum capacity. It is a security environment. There is an enormous amount of work dedicated to make sure that as many requests and wishes are respected as possible, that there is a fair distribution of rooms, not only to and resources as well, not only to the accused in this case, but to all detainees. The group of staff at the detention unit, they often go above and beyond to find creative solutions within what is possible security-wise. So in this respect, there are some instances, and that's what happened yesterday, where we seek assistance from other tribunals to use their visiting rooms when they are available. That often happens on very short notice. They are not able to give us permission to use their visiting rooms until they are fairly sure that they do not need them. So that's and that's what happened yesterday. And that accounts for the sometimes late notice, but that means we have used up all our own visiting rooms are filled, and we are seeking solutions with other tribunals. We are also looking into other options, as defense knows. They are not always the preferred options by defense team, but there are video options, and there are visits in this building, which will happen today, for example. I've looked through, since this has been raised with us a few times, I've looked through the records of the last few months for some defense teams and on specific occasions. And I find that more often than not, or rather, if not always, then almost always, we will find a way to accommodate the requests. So there might be short notice, or you might, hopefully not as short as yesterday, which was just a few hours, but at least a number of days. So we'll try to continue to do that. It requires quite some coordination and effort on our part, and we are ready to do that, of course. We'll ask for some patience from the defense teams for us to be able to do this. I think that's what I need to say. Thank you.
Perhaps a joint meeting with at least the lead counsel and Jonas's department at the registry would be helpful, so that everyone can understand. The problem is they have to borrow a room from ICC, for example, and the ICC won't give the release until they're sure they don't need it, which means that the 10-day notice would not work. You might be told you might be able to be there that day, but it's very difficult to give you a firm answer when they know they're full on that date that you've asked for. So I would suggest you take the opportunity to discuss this further with Jonas and his office. I think I understand the problem. We can't fix it. You know, we don't run that prison. We don't run that detention center. So we will do all we can to help and to make sure that you have the right to see your clients. But there are certain limitations on what we can accomplish. I think a joint meeting would be a very good idea, especially since we're going to have a long period of time now with not daily contact with people, so it would be worth your while. And I know Jonas will accommodate that. Anything else? Thank you for the comments, by the way.
Yes, Your Honor, just one other issue.
Yes, go ahead, Mr. Roberts.
Partly just to prove that I was following for the last 2 hours, but also there's one pending request for an extension of time to respond to a bar table motion. That's F3114. And counsel for Mr. Thaçi had requested an extension until the 5th of May, which wasn't opposed by the prosecution. And that request was submitted on the 17th of April. I just want to check or inquire with the panel whether that's authorized and that we have until the 5th of May to respond to that filing.
Without objection, I will make an oral order right now that that extension is approved, and you may count on that.
Much obliged. Thank you, Your Honor.
Just a minor point, but do you intend for us to reconvene at 2:30?
Yes.
Okay.
Yes, I do.
If there's any chance of doing that earlier, that would be greatly appreciated, but
We'll do our very best to be available at 2 o'clock, but we have to make some more orders.
that's fine.
And you have to listen to me read more orders.
Thank you.
All right, we're adjourned until 2 o'clock.
All rise. All rise.
Be seated. Before issuing the remaining oral orders, the panel indicates to the parties and participants that at this stage it is not minded to schedule an oral hearing in the context of the Rule 130 litigation. The panel also indicates to Victims' Counsel that he is expected to be ready to present his case in the month of July. Lastly, regarding the Salimi defense's query on F02785, the panel is working on the matter and will issue a decision as soon as possible. In the meantime, the panel invites the defense to coordinate with the competent people within the registry to try to resolve any difficulties associated with communications with close relatives. The panel will now issue a few more oral orders. First, the panel orders the defense to file its joint Rule 130 motion by Monday, 2 June 2025. That's the 2nd of June in 2025, or within 14 days of the panel's last ruling on admission of evidence, whichever is later. The SPO is ordered to file its consolidated response by Tuesday, 1 July 2025, or within 30 days of the Defense Rule 130 motion, whichever is later. As prescribed by the Rule 130, paragraph 2, no reply will be entertained. Regarding the requested extension of the word limit, the panel is satisfied that good cause has been shown for an extension of the word limit for both the Joint Defense Rule 130 motion and the SPO's consolidated response. Pursuant to Article 36 of the Rules on Files and Filings, the panel hereby grants an extension of the word limit for the Joint Defense Rule 130 motion to 20,000 words, and for the SPO's consolidated response to 20,000 words, with an indication that the parties should focus in their filings on matters central to the Rule 130 litigation. This concludes the panel's 10th oral order. The 11th oral order on deadlines for victims' case. The panel orders Victims' Counsel to submit no later than Wednesday, 28 May 2025, 1, a list of proposed witnesses to be called should the panel find that there is a case to answer. 2, the statements and/or reports of these witnesses, if they exist, and summaries of the witnesses' proposed evidence, as well as reasonable estimates for the anticipated time needed for direct examination of each proposed witness. 3, a list of evidentiary items to be tendered should there be a case to answer, together with an indication of the manner in which counsel prepares to tender them. And 4, the roadmap to the victim's case, as well as any motions under Rule 153 to 155, bar table motions, and any other related filings pursuant to the rules and the panel's order on the conduct of proceedings. The parties are ordered to notify the panel and the other parties and participants no later than Monday, June 9th, 2025, 1, whether they object to the admission of the Victims' Counsel's proposed evidence, and if so, which parts, and 2, which witnesses they wish to cross-examine should there be a case to answer, with a reasonable estimate for the time needed for cross-examination of each witness. This concludes the panel's 11th oral order. The panel will now issue its oral order on the Thaçi defense request for a briefing schedule for submissions on the admissibility of obstruction-related materials gathered through special investigative measures authorized by the pretrial judge. On 15 April 2025, in filing F03120, the SPO filed a motion for admission of materials related to alleged obstruction of these proceedings. On 17 April 2025, in filing F03127, the Thaçi defense requested that the panel set a briefing schedule authorizing the defense to, 1, file updated submissions on the exclusion in limine of such materials by 30 April 2025, and number two, to file a response to the SPO's motion if necessary, within 10 days of the notification of a decision on the exclusion request. On 18 April 2025, in filing F03132, the SPO responded that the Thaçi defense request should be rejected. On April 23rd, the Thaçi defense orally responded that its request should be granted. Having considered the Thaçi defense's request and the SPO's submissions on that point, the panel is of the view that the litigation concerning the materials tendered by the SPO should not and need not be bifurcated. The panel is satisfied that any submissions regarding the admissibility of materials tendered by the SPO can be effectively addressed in response to the SPO's motion for admission of such materials. Regarding the Thaçi defense's argument that the panel has ruled that the defense is entitled to a separate briefing period to litigate the admissibility of the relevant materials, the panel notes that in its decision F02501, it ruled that the Thaçi defense can advance the same arguments as raised in its prior requests for exclusion in limine, not that it is entitled to a separate briefing period. The rules do not entitle the parties to separate litigation in limine in respect of admissibility, although the panel could consider it convenient to do so in its discretion. This is not the case here. The panel therefore rejects the Thaçi defense's request. This being said, that should the defense wish to seek additional relief in limine in relation to this matter in a separate filing where its submission cannot form part of its response to the SPO's motion for admission, this should be done by the same deadline set by the panel for the response to the SPO's motion. In this regard, the panel notes that the Thaçi defense's request for an extension of time and word limits to file its response to the SPO's motion. Considering that the deadline for our response to filing F03120 is Friday, 25 April 2025, and that the SPO submitted that it would not oppose reasonable extensions of word or time limits for such response, the panel is satisfied that good cause has been shown for a limited extension of time limit for the Thaçi defense to meaningfully address all issues arising from the SPO's motion F03120. The panel therefore grants an extension of the time limit to file any in limine motion and respond to filing F03120 until Friday, 2 May 2025. Regarding the requested extension of the word limit, the panel is of the view that a total of 18,000 words for the in limine submission and the response to the SPO's motion is excessive. The SPO is nevertheless satisfied that the panel is nevertheless satisfied that good cause has been shown for a limited extension to a total of 10,000 words for any in limine submissions and response to the SPO's motion. The panel leaves it to Council's judgment how best to use its submission between the two filings or a single consolidated filing if it is so preferred. This concludes the panel's 12th oral order. Lastly, the panel vacates the court schedule until May 8, 2025. The panel will advise the parties and participants regarding the next sitting day. Mr. Dixon, have you had a chance to consider the time frame that we talked about earlier?
Your Honour, unfortunately not at this point, but those discussions will be taken up as soon as possible and we'll revert if we are able to.
Perhaps you can all just respond in writing if that's the case.
Yes, that will be the quickest way, I expect.
All right. Anything from anybody else?
The only matter from our side, Your Honor, is, and it's premature to ask now, but just to flag it, the panel in case 7 on the Rule 130 decision set a Rule 119.2 deadline for the defense running from a target date. And we consider that to be a good practice. When this panel is able to give a target date for a Rule 130 decision, whenever that would be, we would ask that a similar deadline be given to the defense for Rule 119.2 information.
Thank you. Any comment on that?
Your Honour, no comment on that, but just one additional matter to raise, please. Your Honour, the panel ruled this morning in relation to an extension of a word limit on filing 3056. That is the joint 155 and 153 motions for 3 witnesses, 4260, 4738 and 4574. Now, as the panel is aware, the defence have endeavoured at all times, wherever possible, to work together and work jointly. And as the panel has also recognised today, that involves an incredible amount of coordination and teamwork to combine our submissions wherever possible and unite our submissions in one filing. We, as is common practice, have sought to do that in relation to this. One of the difficulties with that approach is there are inevitably competing interests and inevitably different issues that need to be raised by each of the 4 teams. This filing in particular is dealing with 3 witnesses, 2 of whom are particularly substantial and 2 of whom go to very core issues in this case and serious issues that are central to the allegations in this case. We have exhausted all of our best endeavours to, as a team of 4, bring the word count down as far as we possibly can. We only come to the panel on rare occasions to seek an extension of the word limit when absolutely necessary. The application made this morning for an extension of 3,000 was the minimal extension that we sought in light of the submissions that, in our view, must be made in order to reflect each of the 4 defendants' competing interests. Were we each to file separate filings, which we would be entitled to do so, the panel would receive 4 6,000-word filings, which would be 24,000 words for the panel to consider. What we are simply asking for is for us to have the opportunity to combine 24,000 words down to 10,000 words, which is more than half what the panel would otherwise be in a position to receive were we to work separately. In that less than half word count, we will be able to adequately reflect all defendants' competing interests in relation to these 3 witnesses. So we would ask the panel to please reconsider the extension of that 3,000 words, which in our submission is in the interest of justice, in order to reflect all 4 teams. If the panel is not minded to do so, in the alternative, we would ask the panel or put the panel on notice of the fact that what we would propose to do is for each of the 3 witnesses be responded to by an individual defence team. So that there would be 3 separate filings, each at 6,000 words, which would total 18,000, almost double the joint word count that we are requesting. So we would ask the panel in those circumstances to please reconsider. It is a rare instance when we would ask a second time for reconsideration. We have cut it down to the bare minimum. It's simply not enough.
Thank you.
We'd also simply just add the SPO it does not oppose. We don't believe any extension of the word count. We are being as economical as possible with these words, but we are simply struggling with the current goal that we are working towards. Thank you.
We'll grant your request.
I'm grateful, thank you.
We're adjourned.
You're all right, I'm so sorry.
Huh? Oh,
Sorry, I believe Mr. Ross is before me.
Thank you very much.
Go ahead.
Yes, sorry, Your Honour. one clarification from me, if I may. This morning I mentioned, and it's the provisional transcript, page 30, at line 6, I introduced the topic of a substantial number of victim statements that we are in the process of preparing. And I just want to be clear where they fit into the oral order that's just been made in respect of the service of our case. What I said at page 30 was that we were going to introduce those in the proposed filing, which is now the 28th of May, inform everybody in the panel what they are and what the basis of them is. But I can't honestly see that they're going to be ready to be provided by the 28th of May. And the reason for that is that, apart from anything else, we want them to be signed. And it's a very laborious process. I'm sure I don't need to go into the details. But
So you're suggesting you will give a description of everything, but you won't have the actual document?
Exactly. And what I said this morning was that we saw that coming rather later in the sequence of events. And the position will be these will be documents that deal with harm. There'll be a lot of them, and they won't be ready by the 28th of May, but they can certainly be served, if I say, at or before the victim's case in July.
Well, could we say July 1st, no later than July 1st?
Yes. Yes, thank you.
Let me see what. It seems the consensus on this would be that on the 28th you submit those that you have, and then on a rolling basis continue to do so that they are completed by the 1st of July.
Yes, we can do that. Thank you.
Will that work for you?
Yes, it does. Thank you.
Mr. President, just if
He
I
was
could-
up first.
sorry.
Simple clarification, Your Honour. Your order granting the Thaçi's request for extension of time and word limit, it referred only to Mr. Thaçi. Am I correct in assuming that that would also apply to other accused mentioned in filing F03120? That would be us and Mr. Vaselli. It's F03120, the obstruction materials. We are also concerned in that filing to a lesser extent, and so is Mr. Vaselli. Does the extension apply to everybody?
You're going to file separate pleadings on this, not a consolidated?
I believe so, yes.
Well, go ahead.
Yeah, I can say we need all of those 10,000 words, so they would have to be a separate filing.
It may be the case, Your Honour, and I have to discuss this with
So how many words do you need?
I don't believe we would need an extension as of now. I think we're fine on that. We were mainly concerned with the time limit, to be honest, Your Honour, which is to the 2nd of May, 2025. Because it only concerns 7 excerpts for our client.
2nd of May is adequate?
Yes.
Yes, all right.
Thank you.
And Your Honour, given the nature of the filing, we would need to respond separately as well, and we would seek the 2nd of May as well. No extension of words needed.
Thank you very much. So is that clear for everybody?
And the same for Vaselli.
All 4 of you can file what you wish on that within the normal page limits by the 2nd of May. All right? Now, Mr. Misicic.
Thank you, Your Honor. Just in response to Victims' Counsel, I just wish to preserve our position and make sure there's no prejudice to the issue of us receiving statements of victims by July 1st and then the victim's case, as of right now, starting in July, that without having seen what's coming.
Well, that's probably exactly what's going to happen. we probably will start in July with his case.
Yes, but I guess I'm just saying, I don't know what's in those statements and what purpose they're being submitted for, but to the extent that we will object or potentially oppose 153 or 155 applications, that may be relevant to your considerations of what we hear from victims, from the victim's case in July, and whether there would be a need to call further victims for
Well, I don't think
testimony.
anybody's trying to cut off your ability to object to anything. We're just giving him the dates that he shall comply.
That's fine. I'm just trying to preserve our position that that might not be sufficient notice for us to actually be ready to go in July, other than with the expert witnesses, which I assume we're getting in May, as discussed earlier. We hopefully will be ready to go on those, but if
I think, Mr. Laws, you correct me if I'm wrong, but you indicated it was a limited number of statements.
So the statements that I've raised just now for clarification is a very large number, but if I can put Mr. Mistich's mind at ease in this way, these are not statements that are going to be served on the parties and on the court on the basis that if they are rejected, the victims will be called to testify. That's not going to be the position. These are statements that come from a somewhat different procedural basis to the Rule 153, 154, 155 regime, and we'll explain that in the filing in May more fully.
Mr. Laws, just one question. Is it still your position that you will call all your witnesses and leave enough time for reasonable cross-examination, and all of that will happen within 1 week? Is that correct?
Yes.
So-
1 week with the possibility to go into a second, but as best I can gauge it now, I can't see it requiring more than a week.
So the total number of viva voce victims who are going to testify can't be very high?
Very few, if any. I can't give that number now because there are ongoing conversations in respect of that matter, whether anyone will want to testify. But if they do, it's going to be a very small number.
Thank you.
Does that satisfy your concern to some extent, anyway?
to some extent, but as I said, I just wanted to preserve our position on the record that our position is without prejudice to any
I don't think
objection.
there's any question about that. So.
Yeah, perhaps I can make it even clearer. People that we're going to call to testify live in July or whenever it is, they will be identified in the 28th May filing, no question. I can see Mr. Mistich is finally happy.
That is a relief. Thank you.
Anybody else? No more clarifications of my perfectly clear orders? All right, we're adjourned.
All rise.